Welcome back. We close out our review of criminal cases with the Court's constitutional and civil rights decisions involving the field of criminal law. Let's start with the Fourth Amendment and that perennial favorite, exigent circumstances. Under the exigent circumstances exception of the Fourth Amendment's warrant requirement, the exigencies of a situation may make the needs of law enforcement so compelling that a warrantless search is objectively reasonable under the Fourth Amendment. One of the recognized exigent circumstances is when there is a clear need to prevent the imminent destruction of evidence. Well, in this term's decision in Kentucky v. King, the court faced a situation where police officers had chased a suspect who had just been witnessed by undercover officers participating in an undercover drug sale into an apartment complex. The officers knew that he was in one of two apartments that were across the hall from each other, but they didn't know which one. They knocked on one of the doors and announced, "Police, police, police!" They immediately heard people inside moving, things being moved around, and sounds that made the officers believe drug-related evidence was about to be destroyed. Now, I'm not exactly sure myself what that sound is, but the police have very sensitive ears, you know. In any event, hearing such noises, the police announced they were going to make entry into the apartment forcibly, and one of the officers kicked the door down. They did indeed find illegal drugs. The testimony was that the officers did not threaten to enter forcibly until after they heard the sounds that made them suspect evidence was about to be destroyed. Now, over the years, lower courts had developed an exception to the exigent circumstances rule known as the police-created exigency doctrine. Under this doctrine, police may not rely on the need to prevent destruction of evidence when that exigency was created or manufactured by the police themselves. Unfortunately, the lower courts had not agreed upon any one formulation of this exception. Writing for an 8-1 court, Justice Alito resolved the conflict in the circuits by adopting the following simple, straightforward rule. The exigent circumstances rule justifies a warrantless search when the conduct of the police preceding the exigency is reasonable under the Fourth Amendment. Thus, where the police did not create the exigency by engaging or threatening to engage in conduct that violates the Fourth Amendment, warrantless entry to prevent the destruction of evidence is reasonable and allowed. The court had assumed that the sounds heard by the officers were of such a character as to trigger the exigent circumstances rule, but the record below was not well developed on that point, so the court remanded for further proceedings. Good luck, lower court. Justice Ginsburg was the sole dissenter, and the tenor of her dissent is summed up in just the first two sentences of the dissent, which read as follows. The court today arms the police with a way routinely to dishonor the Fourth Amendment's warrant requirement in drug cases. In lieu of presenting their evidence to a neutral magistrate, police officers may now knock, listen, then break the door down. Never mind that they had ample time to obtain a warrant. Justice Ginsburg certainly has a practical point here. There would seem to be a high likelihood that people engaged in illegal drug activity will respond to a knock on the door by police with panic. That, I guess, sounds very much like efforts to destroy evidence. On the other hand, why should Fourth Amendment jurisprudence be specifically crafted to protect criminals from their own self-destructive behavior? Oh, there's a kicker here. The kicker with this case is that the police officers actually had entered the wrong apartment. After arresting the folks in the apartment that they mistakenly entered, they crossed the hall and also arrested the person who had been involved in the undercover drug deal. So it was a twofer for the police, and apparently a target-rich environment in that particular apartment complex. In fact, one wonders under the holding whether the police can just knock on all of the doors in an apartment complex and wait to listen for sounds of evidence being destroyed. Well, perhaps that approach would be deemed unreasonable. Our next case deals with a very narrow jurisdictional issue that arose in the context of a procedural due process claim. In Skinner v. Switzer, the court resolved an issue left open in District Attorney's Office v. Osborne, whether a convicted state prisoner seeking DNA testing of crime scene evidence may make a procedural due process claim under Section 1983 when the prisoner is denied testing under the state statute as interpreted, Or is he instead limited to making claims only in a petition for a writ of habeas corpus? The Supreme Court held that federal courts are indeed available to hear a procedural due process claim under Section 1983, so long as the relief being sought is limited to a declaration regarding the constitutionality of the state's DNA testing statute, and does not necessarily provide or imply relief from the sentence. That standard was met here because the testing by itself would not necessarily result in a shortening of the sentence, since the testing might confirm the basis for the conviction or be inconclusive. The only basis for denying jurisdiction was the so-called Rooker-Feldman doctrine, which holds that lower federal courts do not have jurisdiction to sit in review of state court judgments. The court held that Rooker-Feldman applies only when the federal court's action and judgment would actually review and set aside a state court judgment. Here, the petitioner did not seek to have any adverse state decision set aside. Instead, the petitioner pled an independent cause of action under Section 1983. Admittedly, the petitioner had raised the due process issue in state court and had lost that issue. But the fact that a litigant seeks to relitigate an issue in federal court does not by itself trigger Rooker-Feldman. Relitigation problems are resolved by the rules dealing with preclusion, but those rules, unlike Rooker-Feldman, are not jurisdictional. The majority opinion was written by Justice Ginsburg and joined by Roberts and Scalia, in addition to Sotomayor and Kagan. The opinion is very narrow, dealing only with the jurisdictional issue and not reaching the merits at all. My guess is that Roberts and Scalia are likely to vote with the conservatives once the merits of these claims are reached, either on grounds of preclusion or under the Due Process Clause itself. Now let's turn from the Fifth Amendment Due Process Clause to the Sixth Amendment's Confrontation Clause. 5 years ago, in Davis v. Washington, the court held that an interaction between police and a victim did not fall within the Confrontation Clause if the circumstances objectively indicated that the primary purpose of the interrogation was to enable police assistance to meet an ongoing emergency. In Davis, the victim of domestic violence was on the phone with the 911 operator, and in response to questions identified the perpetrator. The victim did not testify at trial, but the court held the 911 operator's testimony was admissible, and its admission did not violate the Confrontation Clause. In its opinion this term in Michigan v. Bryant, the court clarified what type of statements made by a crime victim to police officers in the immediate aftermath of a crime fall within the scope of the Confrontation Clause. This time, police officers who were dispatched to a gas station parking lot found the victim mortally wounded. The police asked him what had happened, who had shot him, and where the shooting had occurred. He identified the defendant as the shooter and indicated he had been shot at the back door of the defendant's nearby house. Within 5 to 10 minutes, emergency medical services arrived and took the victim to the hospital, where he died several hours later. Based on the victim's statement, the police went to the defendant's house, where they found blood and a bullet on the back porch. The defendant was subsequently arrested and charged with second-degree murder. The Supreme Court of Michigan held that the Confrontation Clause applied, and the statement should have been excluded because the primary purpose of the statement clearly was to establish the facts of an event that had already occurred, not to enable police to provide assistance to an ongoing emergency. The United States Supreme Court reversed, with a majority opinion by Justice Sotomayor, joined by Roberts, Kennedy, Breyer, and Alito. Thomas concurred in the judgment, dissents by Scalia and Ginsburg, an interesting breakdown of the court. According to the majority, the lower court had misinterpreted Davis by giving it too narrow and rigid a reading, focusing too much on trying to define narrowly what constitutes an emergency, and assuming that the Davis decision intended to define the outer boundaries of the law. As a result, Sotomayor wrote, the Michigan court failed to appreciate that whether an emergency exists and is ongoing is a highly context-dependent inquiry. Analyzing for itself the communications in the case, the majority found that the emergency conditions continued because the victim had been shot and his condition had not stabilized. The communications between the police and the victim were quick and informal, and the police were uncertain whether the threat to the victim or to the public had passed. In these circumstances, The victim's responses to the police questions were not testimonial, and therefore not within the scope of the Confrontation Clause. Given the detailed factual analysis, it appears to me that this decision is going to open up all sorts of factual arguments by prosecutors about how various statements to the police were non-testimonial and were intended to aid the police in responding to an emergency. Indeed, one can almost imagine training police officers to maintain a focus on emergency response instead of investigation as a way of scooping up all sorts of non-testimonial statements. The court will have to deal with those cases in upcoming years. We close our review of criminal law cases with the court's seminal decision in Brown v. Plata, California's prison overcrowding case. A caveat and disclosure is necessary on this one since I am personally involved in the case. Although I was not a party involved in litigating before the three-judge panel, I am serving as the court-appointed receiver in charge of prison medical care in California's prisons. So watch on with that disclosure in mind. By a vote of 5-4, with the court's opinion written by Justice Kennedy, the Supreme Court affirmed in its entirety the order entered by a three-judge panel, which had been convened several years ago to decide whether overcrowded conditions in California's prisons were a primary cause of the inability to provide constitutional levels of medical and mental health care within the prisons, and whether the remedy fashioned by the three-judge panel was appropriate. The state had appealed that order directly to the Supreme Court pursuant to special statutory provisions in the Prison Litigation Reform Act. First, the court concluded that the courts in the underlying actions, Plata dealing with medical care and Coleman dealing with mental health care, acted reasonably in convening the three-judge court. Second, based on the extensive record developed in the cases over a 15-year period, the court concluded that the three-judge panel had properly found that overcrowding was the primary, though not the only, cause of the underlying violations. Third, turning to the relief granted, the court found that the order was narrowly drawn, extended no further than necessary to correct the violation, and was the least intrusive means necessary to correct the violation. Of particular importance was that the three-judge panel's remedial order did not itself mandate any particular set of steps the state had to take to reduce overcrowding. Instead, the three-judge panel recognized that there were a number of different ways of reducing overcrowding, and that the state itself needed to be given the flexibility to determine the method that best balanced the state's interests. Instead of trying to mandate the mechanics, the three-judge panel simply set overcrowding targets that the state must hit within 6 months, 12 months, 18 months, and 2 years. The record before the court established that the state's prisons were overcrowded at about 179%. The three-judge panel calls for no more than 167% within 6 months, 155% within 12 months, 147% in 18 months, and a final level of 137.5% in 2 years. It is now up to the state to implement a plan, and the last sentence in Justice Kennedy's opinion expresses the majority's sense of the matter. The state shall implement the order without further delay. Justice Scalia issued one of his fiery dissents, the sort we haven't seen from him in quite a few years, actually. The first sentence gives you his sense of the matter. Today, the court affirms what is perhaps the most radical injunction issued by a court in our nation's history, an order requiring California to release the staggering number of 46,000 convicted criminals. And, he continues, the proceedings that led to this result were a judicial travesty. Justice Alito, joined by the Chief, issued a more temperate dissent, the basic upshot of which is that the three-judge panel should have given the state more time to try to fix its broken prison healthcare system. Of course, the Coleman case involving mental health goes back to 1995. Apparently 15 years to fix the system wasn't enough for Justices Alito and Roberts. Well, that's it for the criminal side of the United States Supreme Court's October term 2010. Thanks for watching, and be sure to tune in to the next time for our review of the court's remaining constitutional law cases. I'm your host, Clark Kelso. Have a great day in the law.